Good afternoon. Thank you for joining us for this Family Court online forum. We will begin here shortly. Just a little housekeeping. If you have questions for any of the judges, if you will please use the chat feature. Laura will be our moderator today, Laura Russell, and she will be monitoring those questions and asking them at the appropriate times. If you did not receive the Family Court Protocol and the Supreme Court Guidelines, it was included with your webinar link. Please reach out to the LBA and we will be sure to get that information to you. Again, thank you to all the Family Court judges and the Family Court staff for putting together this program for our members. We need this information during this very uncertain time, so thank you for volunteering your time. Laura, I'm going to hand everything over to you. Thank you so much.
Good afternoon. I just want to thank everyone for participating virtually. Thank you to the LBA for setting this up, and also thank you to all the judges that are here today to help us understand what's going on and the new procedures. This is a forum that is a follow-up from 2 or 3 months ago when we talked about the pandemic procedures. And so this is an opportunity to ask questions of the judges who are giving of their time to see what the new protocols are and new Supreme Court rule, and just to talk about those today. I'm Laura Russell, by the way, and I'm the co-chair of the Family Law section of the LBA. And I appreciate you all having me today. And again, the judges, thank you for all being here. And with that, I'm going to turn it over to Judge Hagerty.
Okay, now I can talk. Thank you, Laura. Thank you for the LBA and the Family Law section for hosting us. I don't think you'll hear anything terribly dramatic today, but we just wanted to touch base. Gosh, we're in the 8th month of COVID. And I think when this started, we may have had some ideas that we might be toward the end of it now, but because it does not seem that way at all, we wanted to touch base with you. All the judges have agreed that everybody, not just judges, attorneys, people involved in the court system, but everybody is feeling very weary, with COVID and all the restrictions, and it's, it's kind of depressing not to be able to see people and be around people. So we wanted to be available to you, just to kind of talk through some things. We are trying to tweak things as we go along and continue to review things to make it more accessible for you and your clients and for pro se litigants. Please, please, please feel free at any time, not just during this session, but just in general, to reach out to any of us with suggestions, problems, glitches that you're seeing, because we really, truly are trying to be responsive. The first thing I just wanted to address, I know all of you got the latest Supreme Court rule, which is in response to Jefferson County and some other counties being considered in the red zone. That is not going to change anything about what we're doing. We're not going to restrict what we're doing or limit what we're doing as far as kinds of cases. Family Court is full throttle, and we have been full throttle since the beginning of July when the courts reopened. We're not just hearing emergencies, as you all know, we're hearing everything. Our schedules are just as full as they ever were. The way we're interpreting the newest Supreme Court rule is that we need to be even more careful about doing things, making sure that we're doing things remotely as much as possible, making sure that when people are in the courtroom or in the courthouse, we're observing all the safety guidelines, like the social distancing. We are interpreting that the rule does still give us the discretion to approve some in-person appearances when it's appropriate, and because the language is should, everything should be conducted remotely. We're conducting, I would say, probably 95 or more % of what we're doing remotely anyway. But it's important to have a little bit of leeway because there are some cases where people request to appear in person and we can still approve that. Also, we want to continue to be accessible to pro se litigants who sometimes just show up, particularly on the dependency and domestic violence dockets. So none of that will change. I know prior to today, an attorney reached out and asked if the Supreme Court was going to give any more guidance on compliance with parenting schedules and withholding children, given that we're in a red zone. So I did reach out, and the answer is no. The Supreme Court order, it's number 2020-65 that has that language in it, is still in effect because it was in effect until further order of the court. So that those guidelines are still in effect, but there's not going to be anything more specific or anything that mentions that Jefferson County is in a red zone and therefore things are different. I do have some good news. We honestly have been working really hard to kind of try to streamline things and make it more simple. A couple of the divisions had been using Skype for remote hearings, and we're waiting to see what Teams was going to be like and if that would meet our needs. We had a training session with someone from AOC, and we literally compared side to side Zoom and Skype, and we decided that Zoom best fits our needs right now. So the judges who are not yet using Zoom, except for Division 2, are going to be transitioning into Zoom very soon. And we're all going to start using recurring links that we're going to send out to you in a chart format so that it's easier for you to get links for hearings. And there's not so much back and forth communication with our staff and you to make sure that you have the links. So we're in the works on that. And hopefully we'll be able to get that done very, very soon. So Judge Haney continues to use the Conference Call USA for his hearings, and some of the judges who are using Conference Call USA for motion hour are still going to continue to use that. I know up in circuit court, the judges are the board with what formats they use. Some of the judges just use Conference USA for everything like Judge Haney does. So the judges who use Conference Call USA for motion hour will continue to do that. Judge Haney is planning to continue to use Conference Call USA for his hearings. Judge Ward's going to kind of give an update related to that in a few minutes. We also are aware that there have been a lot of issues with the U.S. Postal Service. Of course, you know, the election is proof of that, that things are delayed and can be delayed. So those of us who are not doing e-signing with orders yet are in the process of starting that. There's a couple divisions that we're not yet doing that. They're in the process of getting on board with that. In the meantime, they have agreed that their staff will scan and email orders in addition to putting them in the mail. And that'll be to pro se litigants that we have contact info for, email addresses, as well as counsel. So that will that should have already started, and if you know it should start next week, if not, because we've been talking about that for quite some time. There is a protocol that we put in place locally. It began on June 1st of 2020. You all were sent a link with the link for this meeting. I want to reiterate part of that as it relates to motion hour. When I sent out that initial email, we were under the impression that the Supreme Court would adopt a temporary local rule that dealt with this. And what I was informed later is that the whole protocol was adopted as a temporary local rule. So you didn't get notice that there was a new temporary rule, but it's provision 6.6 of the Jefferson County Family Court emergency protocols that began on June 1st. And that provision states, except where prior attempts at resolution would be inconsistent with the family court rules or any applicable statute, all counsel or pro se parties must make a good faith effort to resolve any dispute before seeking court intervention. All motions to the court shall be accompanied by a detailed certification of counsel's or pro se movants' attempts to resolve the dispute prior to filing the motions. The certification should include the dates and/or times of any communications, discussions, mediations, offers of settlement, or good faith attempts to resolve the dispute at issue. A Jefferson County Family Court local rule is forthcoming, which that was included in the protocol. So it won't be, this is considered a local rule, this protocol. That's what the Supreme Court ultimately did on that. I'm bringing it up because we have not seen consistency with that being done. We know have not been consistent with enforcing that, but we want to put everybody on notice going forward. We are going to be consistent with enforcing that throughout the board. All 10 family court judges are consistently going to enforce that. And that protocol is also included on the family court website that Judge Brown created for us. So you can get all the Supreme Court orders and you can get all the protocols that are in place on that website, as well as the AOC website. Judge Ward and Judge Brown also wanted me to mention that the next meeting of the divorce subcommittee will be on December 3rd at 4 o'clock. Announcements will be made, links will be sent out, and everyone is invited to attend that. On that note, we're trying to, I've been asking for some time, and we're getting some movement with reactivating the subcommittees so that people have a platform to discuss the divorce cases. That's a subcommittee. We have a domestic violence subcommittee, which I'm going to be chairing. We have a paternity subcommittee. We have an adoptions and TPR subcommittee and a dependency subcommittee. So we're going to be reactivating those subcommittees so that you can interact with us and other community partners, and we can kind of talk through issues related to COVID and anything else in those subject matter areas. I think that is it for my announcements. I did want to mention one more thing about the new Supreme Court rule related to COVID. It did close down in-person operations for the clerk's office. So there's a note to that effect in the anteroom as you come into this building. There's a phone number that you can call if you need services, like looking at a file, something like that, and they'll accommodate you. But it's no longer set up so that you're admitted to the building and can just walk in to the clerk's office. You have to call and make arrangements. The box for filings is still out there. And I know that we have made them aware that we would like those to be clocked when they're retrieved. We may need to get an update from Samantha Graves, who's our family court clerk's office chief, about where we are on that, because I know that the request was made whether there could be a stamp at that box. I know there is not right now. So I'll work on that and get an update out to you guys. So with that, Laura, I'm going to see if there's any questions for us or if you want to move on to the next judge with some announcements. Thank you, guys. And thank you all for being here today.
Thank you, Judge. I don't see any questions right now. I know there was one previously submitted about the orders being more consistently e-filed, but you would do that. So thank you.
Okay.
So I think we're ready to.
So I think Judge Ward was going to address some things next. We sort of assigned everybody a little topic to cover, and obviously we're all open to questions at any time as well. Judge Ward?
Thank you. I also want to thank everybody for taking time out to be here today. It's we know it's been challenging to be able to communicate with everyone about all the different changes that we've all experienced over this last how many months now? I don't know. I'm losing track. We're going into close to a year, I guess. But anyway, so we today my portion was to update. Hopefully, everybody. I'm sure everybody really has already heard, but we wanted to take this opportunity to, as a term, to publicly thank Judge Ellie Kerstetter for her service as interim judge in family court and just holding down the fort in Division III. It's a difficult transition. We get invested in the people that we spend time with, and we've certainly enjoyed having her as part of the family court term. But we're also looking forward to welcoming our newest family court judge, Lori Goodwin. And she's going to come to us from the Legal Aid Society. And what we understand is essentially as soon as the election results are certified, that it could be a very quick transition. So that transition doesn't wait till the first of the year like it would with a regular election. That is just, it's going to happen very quickly. So you all can be, we don't know the exact date yet, but you can expect that transition is going to happen fairly quickly. Also on the horizon is Judge Smith-Haney has announced that he will be retiring soon. At this point, we understand his date is going to be the end of the year, so December 31st is what he's anticipating. He has indicated to all of us that he wants to make that transition as smooth as possible. And in fact, I think initially he was going to retire at the end of November and decided to extend that just to give us all some more time and to make those adjustments and anticipation. So that position will come open for a vacancy, and hopefully, I think we're doing all the stuff that needs to be done kind of in advance to let the higher ups know that that is coming and there'll be some need to fill there. So hopefully, we won't have any lapse in having coverage for a division, because we all know there's lots of work to do in family court. And so we'll start planning for some type. If anybody has any ideas for how we could have any type of safe COVID send-off for Judge Haney, that is something that we'd be open to considering if we can all figure out a way to do that. That was all that specifically that I had to announce today. I know that, and I just want to apologize because I think Judge Ogden and Judge Calvert, they're both on this call, but they were not able to, for technology reasons, not able to get into the presenter link. And so they are with us today. You don't see them on the screen. And I know Judge Ogden was going to update us a little bit about paternity docket. And I don't know if you want me to go into that, Judge Hagerty. I'll do the best that I can if you want me to chime in on that. And
yeah, they are both getting the message that their browser won't allow them to get in. So I apologize. And I know that we had something from IT go to try to help, but they have not been able to get in yet. But yeah, if you want to say a few words about the paternity docket, that would be great.
I think, I know the main thing is that, so if you are an attorney who sometimes comes in on those paternity dockets, the main thing, as far as I understand, is for me, I know personally, that has been the hardest docket to get everything remote because of the involvement of the county attorney's office. But I want everybody to know that we continue to work with the county attorney's office and to try to figure out ways that we can do that remotely, even though it's taken us a long time. If you have, I know on my paternity docket, and I think some of the others are doing the same, any of the visitation only type issues, those we are able to, we just reach out to you in advance through our case specialist and let you know that, that there is a Zoom link, or I guess everybody's going to be using Zoom links. So we are pushing in every way possible to address everything remotely. There just are a few, those are files that are it's a little more complicated because they are confidential, and those county attorneys are involved and need the file access. And so we've got some problems there, but we're moving along on that. We continue to push forward on that. Anything else about paternity from the other judges that, because I wasn't sure of everything she was going to cover on that.
I think you've touched exactly what I'm doing. If it's a visitation or custody issue, I'm asking people to get circuit time, just to cut down the sheer numbers that are coming to that kettle call docket. That's something that I'm doing as well. So I think that we kind of all agreed on that. I don't know if everybody is doing it that way, but I certainly am.
And so the only other thing that I would just add is that, so we are going to continue the divorce subcommittee regular meetings quarterly. So we've got that one coming up in a month from now. We did take all of the minutes from the first meeting and we went through all of that at our term meetings. And so you can see from some of the things Judge Hagerty has announced today has come from that, the agreement that we're all going to go to Zoom, that we're all moving towards that. We're all working towards getting to e-filing. It's just going to, unfortunately, it just takes some time to get all of that going. Let me see, I made some notes and I'm going to look through that to see if there was anything else. We've talked about simplifying the process of, you know, and I know some divisions have reduced the number of different links that they use. And so, but that is something we continue to talk about and work on.
I don't want to interrupt, but we have a question from Ms. Ackerson. What is the best way for an attorney to get an order signed to view a paternity file?
So I know that I have received those requests through email, and I thought that was ingenious because it's so simple and it's not like so they just emailed me their PDF of the request and I just signed it and emailed it right back to them. So that, I don't know if everybody agrees, but I thought, well, I didn't think of that idea, but I thought it was genius because like you don't really still have to do that on paper. In person. Which that reminds me too, we had one of the requests from the last subcommittee meeting was about requesting the videotapes. And the question was, you know, I don't want to have to go down to that office to request it. Well, you know, sometimes we don't think of the simple solutions. And actually Judge Ogden was the one who followed up on that and found out that, well, all you got to do is call their office. So you just call the video office, you can request it and they'll mail the video to you. So that can all be done without you having to come down to the video office in person.
Judge Ward, if I may, I'd like to circle back because there was a question about the website that Judge Hagerty had mentioned that I believe Judge Brown created with all the emergency protocols. So I know it's not exactly what you were talking about, but if we could just circle back to that. That's
a great transition for Judge Brown because Judge Brown is one of our tech gurus.
Yeah, I'll let Judge Brown talk about it because she created it, but I was initially assigned to talk about it. But go right ahead.
Oh, I'm sorry.
Nope, it's her baby. She can talk about it. You want me to go ahead, Denise? Okay, so when I mess it up, I'm going to be watching for that eyebrow to be crinkled up at me. All right, so the website is JD.
No, actually, I put the website address down in the chat box.
Oh, there it is.
Yeah, it's been redirected. It's just jeffersonfamilycourt.com.
Okay.
And it'll take you there.
And you can go there. I went on there earlier. My picture's distorted, but
okay, we'll fix that. We'll fix that.
No, that's the way it looks in the jury pool room. But it's very helpful. It tells you what the dockets are. I was able to click that link. It's a great resource. It tells you what's coming up. Has resources on there, and we just want to urge everyone to make sure you're utilizing that because it's just an easier way to keep everybody in the loop. And then if you want to tout some more on your baby, Judge Brown, you go right ahead. But I like it.
We pretty much put out there what we thought would be helpful to everyone, but if there's other information that you would like to see, we can definitely put that out there. And we try to keep the links updated for the Monday motion hours, but we haven't actually put our weekly dockets out there for other courts, like for circuit actions. But if that's something that you all would like to see, we can certainly gather those, and it'll just be a second attachment under each judge to include the circuit cases that we have currently on the schedule for the week. Because most of us do a weekly docket for all matters, and then we do the individual dockets for motion hour. Probably we won't put our district court dockets out there because they're confidential. But I don't know if it would be helpful to have the DV docket information out there. But so far we haven't put that out there, but we're open to your suggestions on what we should do about it.
Along the lines of confidentiality, there was another question that came in, whether or not judges, can we send a sealed document by sending it by email to your secretary, password protected?
I would guess you could. I don't get that many sealed documents, even in regular matters.
I know that, I'm sorry to interrupt you, Judge Brown. I know that I get some password protected emails from Metro Government for the Fatality Review Committee. So to my knowledge, there's nothing, that won't allow us to receive those.
I don't think there is an issue with that. It's the same as a sealed envelope, really.
Yep.
I'll address, another question came up from my earlier comments about requesting a copy of the proceedings through the video record office. And so I've got a report that the video office might tell you, well, it depends on whether the judge recorded the proceeding remotely or not, how long it will take to get that to you. My response to that would, I don't know the specifics of that situation, but what I will say is there is some delay. So if I am recording remotely, like this week we were in quarantine, and so I did all my dockets remotely, and I won't be back in the office physically until Monday. But what I did is I recorded everything on the cloud, essentially. And but for my secretary to copy that onto disk and get that to the video office, she won't be able to do that. She can't do that from home. So she has to wait till she gets into the office to do that. So, and I will tell you that it takes a long time to download those files. And of course, we all are trying to do, the secretaries especially are trying to do more in a shorter period of time while they're in the office. And so there can be a little bit of delay, but I would say, if you are needing something and fairly with a timely, and they're saying they can't tell you when, I would either call the secretary directly for that division and say, I've made this request from the video office and they're telling me they don't have it yet. And we can facilitate getting that more quickly and prioritize that. And I don't know if anybody else has any other suggestions, but that's what I would say, is because there is some delay getting those remote recordings to the video office. So depending on the timing, you may have to make some specific phone calls.
I would second that. My secretary, she might miss a few, but they just made some requests just this week, the clerk's office, and she was able to get those done immediately. Just depending on how big the file is. So you might just email the secretary and just first, we do want you to go through the clerk's office first. So bypass them, but if you can't get it from them within a reasonable amount of time, email our secretary. And they've, especially mine, has been really good about trying to accommodate and get those out quickly.
Now, one of the things that I have done, if I know that the folks are coming back for a hearing in less than 30 days, which happens if you may just have one witness that couldn't be there that day, but you're kind of squeezing that second part in, is that when I send it to the secretary, to my assistant, I will go ahead and ask her to send that to the attorneys in case they want to review it again before the next hearing date. But it's only if you have a hearing date that's coming up in less than 30 days. Other than that, you would go through the clerk's office or through the recording office, and of course we would facilitate if it's still up with us.
There's another question that's coming in. Would the ALC ever think about going to cloud-based videos, avoiding the disk process? Would you all have any thoughts on that?
I just from what I know, I don't think so. I think it's going to take a lot to get them to change. But I'll let the other judges here say what their feelings are on that.
I do not know the answer to that question. I was trying to text real quick to Lauren Ogden to see if she learned anything about that. I think, it's certainly something I think we could bring up to them and just push for. I'll just tell you that everything throughout the pandemic, it just requires a lot of prompting, I guess, to get things to change and happen. But I think that's a great idea. I don't see a reason why in this day and age we wouldn't do that. I don't know, other than ensuring that they can do it on a you know, confidentiality and security issues. But otherwise, I would think that's a good idea.
I would just add that that's really something for the circuit court clerks and AOC to decide, because the clerks are the keepers of the record. So the video records are theirs, obviously. But yeah, that's something that we can mention to David Nichols, you know, especially given that we're all doing things remotely and using Zoom. I don't know if that's been considered, you know, or not. I really don't know the issues related to that other than what the judges already mentioned, but we can pass that along, Mr. Nicholson.
Were you finished, Christine?
Yes.
Oh, okay. All right. Well, just to talk about IT just a little more, just to remind everyone of what Tara had previously indicated, is that we are all migrating to Zoom, and hopefully that will be in place before the end of the year, where we'll all be on that platform in terms of having our hearings. And one of the good things about being on that platform is when we are recording in our courtroom, you can record it right into JAS. So that makes it easier for you to be able to get your copies of the videos for that day. It's only when we are out of the office and doing the recording that we have to record it on our, you know, desktop and then send it in to be downloaded onto a file. But hopefully that platform is going to, everybody being on the same platform, illustrate some of that happening a little faster. Let's see. We're also trying to make sure that we're doing the e-filing on a regular basis to keep the issues down with the mail. We find that this is impacting mainly our pro se litigants because by the time they're getting the motion, and we have probably already entered the order, and then they're calling and saying that they never received it from the beginning. And because of the mail delays, we know it's true that if you send something on Wednesday, they may not get it before Monday. If you send it by the deadline, they may not get it. And so keep from having to have your orders set aside so that they can come in and have their hearing, their notice in their hearing. It's a good practice that if you know the person's address, and in addition to their home address, but their email and their phone number, if that's, or even if you put your number on it. Most attorneys do, but I noticed that not everybody's consistent with putting their email and their phone number. Most people will put their phone number, but not necessarily their email. So if you would add your email to your certificates, that's going to help them be able to contact you or contact us. Now, we do have a sheet that lists all of the case support persons, as well as our assistants, our secretary. It's available on the website. You might include that also. That way they'll be able to contact us directly so that they can get that information on the Zoom. Because the dockets, the motion hour dockets don't go out to pro se litigants. It's only posted and it's sent out via email. So if you have that person's email and you want to send them that information to ensure that they're on that day, that's a good idea to do. We noticed some attorneys had started to do that in their motions as part of the notice. They're actually adding the Zoom link. Now, when we put our one-page document together, which should be before the end of the month, we're going to have the phone numbers so that if people want to call in, then they'll have the member ID and the password and the phone number so that they can simply make the call. Or if they choose to do the link, they can do the link. So we're working on making sure that we can facilitate that process a lot smoother going forward.
I've also noticed some attorneys are really, and it's just, I was very impressed with this. They're really good about, let's say it's Wednesday and you have a motion or it's Tuesday and you want to meet the deadline. They just file it for not the coming Monday, but the following Monday. And that allows for ample time for that motion to make it to the pro se litigant. So I've seen that happen as well. I think if you do all of those things, it could possibly avoid having to remand the motion or readdress it so that everybody has the opportunity to talk.
Yeah, that's a great idea, to give it 2 weeks, 2 motion hours, so that we can be assured that the person has received it in the mail. I mean, and it doesn't only happen to pro se litigants. Other attorneys will say that they haven't, the opposing counsel will say they never received it. So we have to go back and readdress it again. So that's a good idea.
I wanted to, oh, I'm sorry to interrupt, Judge Brown.
Go
I
ahead.
wanted to follow up on a couple more things, just a couple things we mentioned earlier. I'm looking away because I'm emailing questions to some of our partners about some of the issues that have come up. As to the clock for dropping filings in the box in the ante room, the clerk's office, all this started, tried to get a clock out there so attorneys and pro se litigants could clock the pleadings themselves. And there were some issues with setting that up. So they're going to look into that again, but they wanted y'all to know that we do, that they do check it hourly. And they clock everything as soon as they take it into the clerk's office. Jenny Lee and Samantha Graves, who work with us from Mr. Nicholson's office, are here listening. So they are hearing all these suggestions and conversations. The question that Renaud brought up about whether we could record hearings in the cloud, Jenny Lee did respond to and stated that there's a Supreme Court administrative rule right now that requires that audio and video records be preserved on discs. There are plans in place to amend that, and AOC is looking to move to an electronic audio video file. For public cases, they're looking at taking that where they could have the recording available through CourtNet. But that's still all in the planning stages. I just wanted to, since we have those folks on here as well and they're emailing responses, I just wanted to update with those responses. And also say the clerk's office is doing a fabulous job throughout all this. I know you hear us, you say a lot of, when something has gone wrong, and I haven't had a clerk for a little while, so I've had a lot of things mistakes that have been made and things like that. And I've said, well, I don't have a clerk right now. We really depend on them so heavily. And, they are trying to be in compliance with all the social distancing guidelines and the 50% staffing mandated by the Supreme Court. They've recently decided, though, that they're going to change things around a little bit more so that our bench clerks and our stepping clerks are more available to us. They're going to be available 4 days a week instead of the 2 or 3 that they were. The clerk's office really has been a tremendous asset with keeping the wheels on the bus around here. I don't know what we would have done without them. So I just give them a little shout out. And they're continuing to try to improve things because, as things don't work or we see glitches, they're working with us to try to tweak as well. So
There looks like there was a question about the website, but maybe Ms. Russell has answered that question.
Yeah, we put it down there a couple of times, the address.
Okay.
And back to the clerk's office in regard to the exhibits, like we have the rule in place that we would like to get those exhibits at least 10 days in advance. And that is really important, especially when you have pro se litigants. It is really hard to do a hearing if they do not have the documents. It's problematic if you have someone that's just on the phone and you're displaying things on the screen, but at least if they have the documents, they have received them, then at least they can flip through them while they're, in the hearing. But it can cause your hearing to get rescheduled if anyone objects because they haven't received the exhibits in time. And all the civil rules are in place, not suspended at all. So you still have to file your hearing documents and exhibits and let us know who's going to be a witness. All of those things you still have to do. And the clerk's office has been very good about bringing us the documents upstairs, like when they come in, instead of maybe just getting them into the file. They're actually bringing those up to us, especially when they know the hearing is coming up. So we've not had a problem getting them thus far. And then I know sometimes if everybody has a copy of the exhibit, I'll ask the parties if they just want to reference the exhibit, and then we can admit them all at one time instead of them getting displayed on the screen. But that's pretty much up to the parties. Because some people feel very comfortable displaying things on the screen. Others just want to reference it because everybody's looking at it. And then we just admit them as exhibits. So that's kind of up to everybody else on how to do the individual, on each individual case, they can make that decision. And one other thing I wanted to mention. On your circuit cases, it's okay for other persons to be in the rooms with individuals. I know sometimes when you ask someone, is there anyone with you, they already feel like, okay, wait a minute, what's going on? Am I in trouble? It's not necessarily that anybody's in trouble, but we need to know who else is in the room, and they need to be visible on the camera. Because what we are noticing, or what we have come to find out, is that other people are in the room, and if they're outside the view of the camera, then they are sending answers, and we're not getting true testimony from the individual. We're getting somebody else telling them what to say. So if they're in the room, they have to be identified, and they have to be in camera view behind the witness so that we can see them and know that, that doesn't happen very often, but we're just saying it has come up a few times with other people in the room. And, it's amazing how you can see when people just keep looking off to the left or to the right, or, they're doing this because they're trying to read something. They're doing this because they're trying to read something. So, I mean, it's you think you don't see it, but if you think about the courtroom and where the judge is able to see everybody, and you see all the hand movements, everybody's facial, gestures, you can see all of that. And so we're not saying you can't have people, but if it's a confidential case, we do have to have the permission of all the parties in order for someone who's not a party to be in there. But on the circuit cases and the other public cases, we need to be able to see that person and know that they're just observing and not.
That also applies for separation of witnesses too, particularly with pro se litigants. They just don't know. And so I'm working on being better at saying it up front. Is there anyone in the room that's a witness? If they're in the room, they need to leave because of that rule. So that too, I would add.
Right. Or they'll tell you no one's in the room, and then somebody will start talking.
And
exactly.
There's not children in the room. We run into that too. So attorneys, if you all can help us with those things, making sure your clients know they need to make arrangements for childcare, even if it's in another room in the home, as long as there's an adult with them, or depending on their age, I guess that's okay. But we certainly want to try to still protect our children from being exposed to these hearings unless they're being called as witnesses. The other thing I wanted to tag on about exhibits. And, we've all tried to be, I think, more accommodating with the pandemic and just trying to figure all this out together. But and I know personally, I've been doing some more emailing with attorneys, but what we all have to remember is, so we have to make sure, first of all, that there's not any ex parte communications. We can communicate about procedural matters through email, but you can't start talking about substantive issues in email. I still think that's not, I think that would be a problem because it's not simultaneous. If we're all in a video conference or a phone conference, that's okay. But if email, we can't talk about substantive stuff. We can work out the procedural stuff, but not the substantive stuff. And I would also say, so with those exhibits, you all have to be careful because email is not the record. So it's very important to me. I really think all of the exhibits need to be e-filed in advance. And I think that's what our rule says. And it says 10 days. I'll tell you, almost nobody is doing that. And I would just please encourage you all to, you may have to work further in advance than you're used to working because of that rule, but we all really want to enforce that. And we're probably moving towards being more about how we're going to enforce that, because it is problematic when somebody is just trying to email you a bunch of exhibits the morning of the hearing or to your secretary, and they're like, what do I do with all this stuff? So I think that, if you can e-file them 10 days in advance, then we're not going to have that problem, because 10 days is going to give the clerk's office enough time. They'll be in there, we'll see them, and we can access them. So, so that, I guess that's, anybody want to add anything on to that?
Well, I know sometimes I have received the exhibits on the day of, like say both parties decide, send it late, and they're like, okay, I'm not going to object if you don't object. And they send you a bunch of exhibits, but I'm telling you, there's no way that I'm going to look at 27 separate emails that you send me the morning of the hearing. You're probably going to get, you're going to get a continuance, and you're probably going to get, you know, a side eye. Just saying. Because there's no way that the judge can do that. I can't be, we already have enough going on while we're trying to have the Zoom meeting, but then for me to have to go to the other screen and open up the email and make sure that I have the right one that you're talking about, that's just too much. We can't do that. We're not going to be able to listen to what's going on if we're having to, you know, work with these all these emails that you just sent this morning, and judge's email number 5 out of 27. And no, we can't do that. And then the other thing that's a little problematic, I think that we can work it out, is when the litigant and the client and the attorney are in the same room. Sometimes there are communication issues. You cannot hear both parties. And I know some people love to have their client right there with them, and that's fine, but you may have to have them log in from a different device and work out the feedback issues. Because I think I had a couple of hearings last week where the attorney was basically switching the screen, turning the screen from himself to his client, or herself and the client. And the sound cuts out when you do that, because Zoom is a voice activated platform. So it's going to pick up on the voice. So if you're not saying anything, then it's going to stay fixed on the last person that spoke until the other person starts speaking. And if you're moving your laptop around, you're not going to get the sound. It's just not going to work. So just kind of try to make sure that the sound is clear prior to the hearing, because you often log in into these. Sometimes we'll have them open, you know, maybe 15 minutes before. You know, if you feel like you want to check that, just let us know, and then at least our secretaries can open them up and let you come in and check to make sure your sound is working. We can do that. But that was the last thing I had about IT concerns, unless anybody else has anything, or if there's some questions about IT. Yes.
Not about IT specifically, but about, you were talking about exhibits, and there's a question about the rebuttal exhibits and how all the other exhibits need to be 10 days. But how would you like rebuttal? All of you like a rebuttal exhibit?
Well, I would think that since you don't know that until the day of, until you've heard the testimony, then that you probably would have to email to our assistants so they can print it off and bring it to us. And we might have to take a break to print it off and have it before us, to make sure that both the other side has them as well.
Or if you have it, you can just share your screen.
True. Yeah.
And I'll just tell you, Zoom is very little, so you have to kind of minimize the Zoom screen. Go in, get your exhibit, then share screen, and choose the screen you want to share.
Yeah.
And you have to do that.
And you should know that while you're in there choosing your screen, we cannot see that. We don't see your screen until you click share at the bottom right-hand side of the screen for the second time. You click the green button to get in, and it's going to show you everything that's on your desktop. So while you're looking around in your desktop, nobody sees that. Only you. But when you select the document and then you click share again, that's when we all are able to see it. So, you know, don't get anxious that we're seeing all of the emails and everybody else that you've been talking to on your screen, because we do not see that. It doesn't show until you click share for the second time. And then we can see, then it's displayed to everybody.
I have a 1 o'clock hearing, and I just want to add, this will probably be my last comment. What I see here, and maybe it's just the pandemic, but I honestly see that we're going to be moving toward a paperless electronic world. And I would not be surprised if this is just the beginning of it. So I would encourage those who have not started to take advantage and learn this technology to learn it, because I have a feeling that in the future, the court system is going to be it's going to be a technological system. It's going to rely upon internet, e-filing, virtual video calls. So now is the time to start learning that stuff.
Yep.
This is what I see coming in the future.
Yeah, it definitely is. Now, if you log in to Zoom from a desktop, it immediately gives you the option to change your name. Okay? If you do not change your name, you're sitting out there as Galaxy or GS Stylo or iPhone 25, or you just
or Big Daddy J.
Yeah, Big Daddy Jane, or some other crazy name that somebody has out there. If we don't know who you are, you could be sitting there, because just know that if you're on a desktop, please change your name, because we're looking for the attorneys that are on the cases for the motion out. Now, if it's like just, if it's on a case that I can typically we can figure out, the names from knowing who the attorneys are and who the litigants are. But if you're in like a docket and you never change your name, then we don't know who you are. So we're going to go with those names that we recognize. We're looking for the cases and say, okay, we have 2 attorneys on this one. Let's roll with this one. But it gives you the option if you're on a desktop. It will not give you that option if you call in just on your cell phone. So we will usually pull those folks in. But please, I mean, there's no way we can remember your telephone number. Although there is one attorney whose number I said, now, I'm starting to remember your number. I don't want to remember your phone number, but I always know who that is. And I bring them right in to see what they need. But that's, I think because it's close to my number, the last 4 digits of my phone number, that I remember it, but we won't remember that. So if you can change your name, that is like really great. And it looks like Gina has something she wants to say. Judge Calvert has something she wants. Oh, you don't? You just waving at us? Okay. Okay. If we don't, do we have any other tech questions, Laura, that we need to address?
We just had one, Judge Brown. It says, I believe the judges can assign names to telephone numbers. Have we considered doing that?
We can only assign a name when you log in. So like if you log in and I find out who you are and I change your name and I send you back out, then when you log back in, I know when you come back into the call, that same call, then it keeps that. But we can't do that for 25 people in a motion hour. That's why we need you all to rename yourself, because it gives you that option. It says, it's one of the options when you click on the 3 little dots up in the corner is rename. So that's why we're asking you all to do it. Because it doesn't last forever. It doesn't stay that way. So if you log in next week, it doesn't retain your name like that. Only for the call that you're actually on, it'll retain it.
And I think the question, Judge, too, along those same lines was, what about the pro se litigants? Are they informed of that as well, or how is it working with the pro se litigants?
Well, like I say, if you log in from a desktop, it is always an option. The only time you don't have the option to change your name is if you're on a phone. And, a lot of people do log in by phone, so we generally just have to pull them in and ask them to identify themselves. But we're probably going to be going with all the other people who we know in the list before we get down to those folks who are just on a cell phone that, we can't identify them. Unless, they come in and they say, my client is on this, or this is the last 4 digits of their number.
I just ask them who they are, and then I change their name if they're a pro se litigant.
Right, which you can do that if it's a few people. But if you got 25 people in there and you got 8 phones, and a lot of times they don't give you the digits. It'll just say what kind of phone it is. It'll say it's an iPhone. or it's a LG stylo or something like that. So you can't figure that out without bringing them in.
Brown, did you want to talk a little bit about Adoption Day? I know you and Judge McDonald and Judge Webb are working on the Adoption Day that'll occur in November.
Yes, so Adoption Day is scheduled for November the 20th. And that's going to be where we're all going to have adoptions if we are available on that day. So if you have adoptions that are close to being ready or that could be ready by the 20th, let us know. And I don't think we're opposed to doing that again in December if you're not going to be ready by the 20th. But if you're wanting to get your adoptions in before the end of the year, we could certainly set up another day. I think that, November is adoption month. And so that's why we're doing it on the 20th and in November. And so far, I think we have maybe 7 or 8, it looks like, maybe even more. But if you have adoptions that you think can get handled before the end of the year, we definitely want to get those done for you. And I mean, one of the other things about Zoom, I'm always in Zoom trying to figure out what's going on. But now they have filters in there, so you can kind of make it kind of fun and interactive for adoption proceedings, where it can look a little bit more festive. And that's just some of the stuff that they've added to Zoom.
There's one more question, and this one has to do with when do we have to submit for decrees to get entered by the end of the year by 12/31?
We have not talked about that yet, and that is a good question because I know that comes up every year. So how about we talk about that and we look at how folks are going to be available, leading up to December 31st and, what we have as far as resources for getting those signed. And we will send out a blast email like we do with the pre-rulings and motion hour to let you know the guidelines on that. Thank you for that reminder because we haven't talked about that yet. Judge Calvert.
I still think, though, that because of the situation we are operating under, that you all need to file those a lot earlier than you normally do. Because, our clerks are doing a wonderful, wonderful job, and they're back up to about 88% now. But still, try to file things earlier, as opposed to later, because we do want to try to assist you all to the best of our ability. So, for what that's worth.
Well, I have a hearing at 1 o'clock as well, and I know everybody's got a busy schedule and somewhere else to be. Judge Calvert, I'm so glad you got to join us. I'm sorry that you had trouble. Judge Ogden never got in. But
it took IT and 2 people from AOC to get my laptop and my computer. You all know my courtroom is possessed. Anybody who's ever in my courtroom hears me say that about 5 times a day. So.
I think
that's perseverance.
Best right now. But thank you, Laura, again for hosting us. Thank you to the LBA. Thanks to everybody for participating. We'll do this on a frequent basis so that we can have this great interchange. And on behalf of all of us, thanks, guys. Have a great weekend.
Thank you, everybody.
Thank you again, judges.